Imagine walking down the street, police officer approaches, orders you to stop, spins you around, and begins a pat down. Is this type of search permitted under the Fourth Amendment? Well, you might be thinking Terry versus Ohio. Of course, a Supreme Court landmark decision. But I've previously discussed this case on my channel in great detail, and I will link it in the description below. Today, I welcome you back to the fourth part in my 10-part series, 10 most important landmark Supreme Court decisions in criminal law and the myths surrounding them. Today, we're discussing Terry versus Ohio. And what are we going to do? I'm going to briefly discuss the case, very briefly. And then we're going to move on to the 10 myths, misunderstandings about this case, all the decades later. Again, I welcome you back. You can watch all of these videos in any order, but today you're in part 4. So if you've missed the previous parts, watch 1 through 3. They're very interesting cases, of course, Miranda, Katz, and others. Today it is Terry versus Ohio. Welcome back to Lost Test channel. If you're new here, subscribe. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And if you want to support this channel, consider going to shop.loststash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, pins, stickers, and other items. And if you're watching this particular series, if you type in 10 cases, you will get 10% off all the merchandise. Thanks for watching, and let's move on.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
In 1963, Cleveland Detective McFadden was observing individuals on the street. After 39 years on the force, he had an eye for suspicious activity. He saw 2 men pacing back and forth in front of a store, looking in. They paced back and forth about 12 times until they joined a third individual. Now, at this point, Detective McFadden did not observe any crimes, but he thought the 3 men were pacing in order to case the store for potential robbery. So before it happens, he approached the 3 men, and before you know it, Detective McFadden spun Mr. Terry around, placing him in between himself and the 2 other men, and quickly patted him down for weapons. Later, the detective explained in court that he did it for his own safety. He thought, given that this is a potential robbery, he thought that the individuals could be armed. Well, in fact, Mr. Terry was armed. During the pat down, the detective found a revolver on Terry. Now, Mr. Terry was later charged with possession of this firearm, but he argued in court that the search violated his Fourth Amendment rights. He said there was no reason for the detective to approach him and pat him down. So the case goes all the way up to the Supreme Court, where in an 8-1 decision, the court says that the officer could in fact stop and pat down Mr. Terry as long as there's reasonable suspicion that the individual is armed and dangerous. Now, of course, this doctrine is now called a Terry stop or stop-and-frisk. There's many names for it, but essentially, if there's reasonable suspicion that the individual is armed and dangerous, the officer can in fact pat down that individual. This is the holding. Let's move on to the 10 biggest myths about this case. Myth number 1. Police can frisk anyone at any time. Again, just like I said, there has to be reasonable suspicion that the individual is armed and dangerous. What does that mean? It means that no, the officer cannot pat down anyone at any time. The person has to be armed and dangerous. There has to be that reasonable suspicion. And the search itself is also limited. It is limited to the pat down outside of the clothing. The officer cannot go inside. He has to pat down the individual from the outside to see if there are any weapons. Myth number 2. Terry gives police unlimited power to stop you. Again, this is not true. When the officer has reasonable suspicion, he can briefly detain you. He cannot stop you indefinitely. In fact, if the stop is prolonged, it can in fact become a de facto arrest. And what do we need for arrest? The officers need to have probable cause. So, if this is the situation you find yourself in, where the officer stopped you for a long period of time, talk to your lawyer, because you might have been in fact arrested, even though the officer called it something else, like detention. Let's move on to myth number 3. You lose all your Fourth Amendment rights during stop and frisk. That's not true. The officer can only pat down outside of the clothing. So, no, you don't lose all your Fourth Amendment rights, but it does limit your rights significantly. Myth number 4. All Terry stops are fair and unbiased. The court later has to look into the reasonableness of the stop. But of course, throughout the years, people have said that this created, of course, biased stops, racially motivated stops. So there was a lot of litigation since Terry versus Ohio on the limits of Terry, on whether it's even reasonable to have this doctrine. But we do have it, but it is something to consider. The fact that no, it is not true. Not all of these stops are fair and unbiased. Myth number 5. Terry stops apply to all crimes. That is not true. Because we're talking about officer safety, and we're talking about somebody who's armed and dangerous, we're talking about crimes that are generally violent. Meaning, because here the officer thought there was a potential robbery, well, robberies are often associated with weapons. But if the officer stops you for jaywalking, no, that is not a violent crime. The officer cannot pat you down because there's no reasonable suspicion that you're armed and dangerous if you're jaywalking. Myth number 6. Frisking automatically allows officers to search pockets or bags freely. Not true. Again, officers can only pat down outside of the clothing. But remember, once they do the pat down, there's the plain field doctrine. If they feel from the outside that there's a weapon, of course they can retrieve the weapon. But since Terry versus Ohio, we have many cases where the officers patted the individual down and claimed that they could feel narcotics inside the pockets. If the incriminating evidence is apparent from the field, from the outside, the officer can in fact take it out. But of course, if let's say the narcotics are in a pill bottle, well, that's not necessarily incriminating. Pill bottles themselves are not something that are criminal. So if the narcotics are inside some sort of packaging, you can later claim in court that the officer exceeded the scope when he was patting down and taking the evidence out of the pockets or out of the bags. Myth number 7. Terry versus Ohio made stop and frisk legal everywhere forever. Again, back to that it has to be reasonable suspicion that the individual is armed and dangerous. So no, it is not legal everywhere at all times. Myth number 8. Only police officers can perform Terry versus Ohio. This is the question that we often get as criminal defense attorneys. When we're talking about the Fourth Amendment and the Constitution itself, we're talking about limits on governmental intrusions, meaning that private citizens may or may not search you, depending whether you consent or not. That is a separate question from the Fourth Amendment. Fourth Amendment applies to governmental intrusions, not to private citizens. But when we're talking about governmental intrusions, you have to remember it is not only police officers. In fact, ICE agents, maybe fire marshals, perhaps DHS, FBI, all of those different organizations are government, quote unquote. And so Fourth Amendment protects against governmental intrusions. So Terry versus Ohio gives the authority not only to the police officers, but to other governmental agents. Myth number 9, you have to comply with frisk without question. Well, I will tell you, in practice, you should not create altercations with police officers on the street, because you might be picking up more charges. The scope and the limits of stop and frisk will be adjudicated in court. Your lawyer will be arguing that the scope has been exceeded, for example. So leave it to your lawyers to argue whether Terry versus Ohio applied, whether this stop became something more like a de facto arrest, but it is not up to you to be arguing it to the police officer on the street, and he won't listen anyway. Myth number 10, Terry only affects the Fourth Amendment. Well, that's not true. As I said, since Terry versus Ohio, we have questions about biased, racially motivated stops. So of course there's now other questions about discrimination and so on related to Terry versus Ohio. And now in 2025, we're also questioning how can Terry versus Ohio be used by ICE agents during their immigration raids. So here's what you need to know from Terry versus Ohio. It has very much tipped the balance towards police authority, giving them more authority while you're losing your individual rights. So this was Terry versus Ohio and 10 myths surrounding it. I hope you're enjoying this series. There's going to be 10 parts to it. Thanks again for watching the Lost Ash channel. If you're new, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostash.com/merch or shop.lostash.com and check out these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. Thanks for watching.